Hello, good evening. How are you? We are live. Removal defense. Still talking about the same subject. Yes, we're going to talk about I-751 petition to remove conditions on residence. Those that's for conditional green card holders. That's the topic. Who has jurisdiction over the form I-751. That's the subject. I want to talk to you. I want to share some stuff with you tonight. And let me know where you are and where you're actually watching me from. Okay? Let me know in the comment, just waiting for you to get in so we can get started. Let me know where you are. Say hi in the comment. Yes, say hi in the comments. Yes, please like. Yes, please subscribe. Yes, please share. Um, yeah, because we need YouTube to show um, those type of videos to people just like you. Okay, that's the purpose, right? So we want to help you, want to answer some questions. Yes, Wilbur Valestil, how are you? From New York. It's hot in New York today. Yeah, it's hot here too. So looks like summer is still going on. Yes, we're gonna talk about removal of condition, and I'm gonna share my screen with you because sometimes the spouse does not show up at the interview. The question becomes, what am I supposed to do? Yes, you can still remove condition on your own, even if the spouse does not show up at the interview. Oh yeah, I'm doing all right. I'm here. I'm here good. Just trying to do this live session, okay? Yeah, we got 5 people already. Please go ahead and like, please go ahead and share. And if you have a question, just put it in the comments, okay? But I'm gonna share the screen with you because I want to talk a little bit about this removal um, of conditions, okay, on residence. Let me share my screen with you so we can talk about it. I just want to talk about one thing about it. Okay. Share the entire screen. So, yeah, that's the petition, right? I-751 petition to remove conditions on residence. So, who has jurisdiction if you are in removal? USCIS still has jurisdiction over that petition. However, the immigration judge can review, they have the right to review the reasons for the denial of that I-751. But if you're trying to, let's say, um, file for a waiver because the spouse just abandoned um, and they didn't want to file together, right? Because they, first of all, they didn't show up at the interview, and second of all, they did not want to file jointly. Even though you are in removal, you still have to file I-751, a new one with USCIS, and continue your case so that USCIS can adjudicate that petition, because you really want them to make a decision on that petition so that you can, defend yourself better in court, right? So that's the reasons we have this live show, so we can show you exactly what to do. So this is what I want to talk about, okay? If you're filing a joint petition, yeah, that chances are it might get approved. But if you're filing it on your own, you have to have a reason, okay? So if you're filing an individual request because of the death of the petitioning spouse or step parent, this is what you have to provide, right? Copies of the front and back of your permanent resident card, copies of the front and back of the permanent resident card of any conditional permanent resident children, evidence of the relationship, death certificate, that's the big one, if you have crimes and stuff like that, okay? And you go so forth. But what I really want to talk about today is the waiver of hardship. Because if you suffer extreme, you can remove condition on your own too, instead of applying for VAWA, because VAWA usually come into play when you never even receive the actual green card, even the conditional one, right? That's when people go straight to VAWA. But in case that you actually receive the conditional one and then you want to remove it, and the spouse does not want to join you in the removal, and you happen to suffer, but you were battered, or you happen to suffer, you were subject of extreme cruelty. So those are the things that you have to provide, okay? Evidence of abuse. I've talked about it a lot. If you've been divorced, the final divorce, okay? And then that the marriage in question was terminated by divorce on grounds of physical abuse or extreme cruelty. An explanation as to why you're filing separately. If you have crime, disposition of criminal charge, arrest, and conviction. If you're filing from outside of the United States because your spouse or your step parent is residing outside of the United States on U.S. Military or government orders, then you have to put a copy of military, current military or government orders, okay? If you are filing separately because your removal will result in extreme hardship, those are the things you have to provide, right? Evidence of extreme hardship. In the context of immigration, you already know what extreme hardship is. We've talked about it a lot, but you can just go here on uscis.gov and then put extreme hardship. It's exactly going to show you how USCIS consider extreme hardship, okay? It's gonna, first of all, they go with totality of circumstances, then they look at common consequences, then the factor must be considered cumulatively. Yeah, you can, then they have examples, okay? If you read those examples, especially if you go all the way down here, okay, you have examples. If you go down here, you have examples. You see, hypothetical case examples, and it really gives you an idea of how USCIS determine extreme hardship. You can go and read it if you're trying to make an argument for extreme hardship. But if you go up here, you will see really some elements, right? Country conditions, health condition and care, economic impact, social and cultural impact, family ties and impact. Those are the factors and the consideration. If you read it, you have an idea what exactly is extreme hardship, and the totality of circumstances really will help you make the case, right? So, but anyway, that's the evidence you have to provide of extreme hardship. Then an explanation for the reason why you're filing separately. If you have criminal record, you have to provide disposition of criminal charges, arrest, or convictions. If you're filing from outside the United States, again, you have to show copy of current military and government orders. Trust me, those I-751 removal of conditions on residence, petition to remove conditions on residence, those I-751 extreme hardship waiver are really hard to win. So that's why you really need guidance in those type of petitions. However, you can just look and get the ideas when it comes to extreme hardship when you're gathering your evidence. So basically, that's what I wanted to show you in case you didn't see it before, right? Or you might have seen it, but you forgot, right? So, sorry, our job is to remind you. So let me go back, stop sharing, and take some questions. Okay. Anybody has a question? We need to answer some questions. 2 people watching. we need to answer some questions. If you have a question, just drop it in the comment. So basically, we're talking about removing conditions on the residence, especially if somebody is in removal. Who has jurisdiction? USCIS still has jurisdiction. However, the judge can review the reason of denial, right? But if you, let's say you been brought to court after it has been denied, but you still have a case to make for filing separately, you can still file I-751 with USCIS and really ask the court to continue your case. That's exactly what you can do. So let me get to questions, okay? Let me get to questions. Waiting for questions. In the meantime, I want to see the likes. I want to see the likes so I will know for sure who's liking, who's not. Yeah. We come back tomorrow again to talk about maybe motion to reopen and why having a U.S. citizen child is not a guarantee to win. Okay, so yes, we're here. Who has a question? If there's no more question, I'm just gonna hang up and come back tomorrow with motion to reopen and prosecutorial discretions and all those good subjects. So if you don't have a question, I'll come back tomorrow. Just waiting for some people to get in. The lightning here is too much. Make me turn yellow. But anyway, so if you have a question, just put it in the comments. In the meantime, I'm going to check if there's some type of immigration news going on. Let me check. Okay, we have a good news here. Let me share my screen for this one. Yeah, share the screen again. Yeah, we got a great news here. USCIS reminds parolee and asylum that they might be eligible to apply for employment authorization. You are likely eligible to apply for an employment authorization document to legally work in the United States if you were recently paroled into the United States and the parole remains valid. Okay, then you can just go ahead and apply for work permits. Or you have applied for asylum and the application has been pending for at least 150 days. You can go ahead and apply. But for me, the way I work, I do it with this 150 days because once the case has been pending for 150 days, when you apply, still they have to wait for 30 days before they adjudicate the petition. So the way I do it, I just wait for 180 days. Then when I apply, within 2 weeks, you already get your work permit. So that's how I go about it. But anyway, so yeah, that's the reminder going on with USCIS right now. Let me see if there's another news. Oh yeah, we got another news, a good one. Let me just go and see all news. Yep. So we got TPS has been extended for South Sudan. Okay, Secretary Mayorga extends and he designates temporary protected status for South Sudan. So who's qualified? It's going to be for 18 months until May 3rd, 2025. Okay, from November 3rd to May 3rd, 2025. So what is going on? So accompanying this announcement is a special student relief notice for F1 non-immigrant student whose country of citizenship is South Sudan. So the student may request employment authorization, work an increased number of hours while in school. That's specifically for the student, right? F1 student from South Sudan because of hardship. USCIS is pretty much allowing them to work an increased number of hours while in school. It doesn't apply to every student, okay? Don't be going around and working for more than allowed by US laws when it comes to students, because you don't want to get into student violations. So yeah, so this is really good. How many people? Yeah, 180 additional Sudanese will be actually, yeah, will be eligible. So DHS recognized that not all registered men receive a new employment authorization document before the current expire, and that's why it's automatically extending to November 3rd, 2024. Okay, which is good, right? If you apply for work permit and you haven't received it, it's automatically being extended, so you don't have to worry about it. That's for TPS. We're talking about South Sudan, okay? So what else is going on? Yeah, that's it. Those are the great news of stuff sharing. Let me see if we have a, yeah, we got a question again. Well, if you're in removal proceedings, right, employment base, you already overstayed the visa. The moment somebody find themselves in removal, they already overstayed the visa. Adjustment under employment, um, it pretty much not really going to work based on the fact that failure to maintain non-immigrant lawful status, like overstay visa, unless you have those type of 245 exception. Okay, we talked about it. You can verify. Hi Gonzalez, how are you? Thanks for coming. We're almost done because we don't have a lot of people today. We're almost done. But anyway, so what I was saying is that, yeah, Wilbur, it's pretty much almost like impossible based on the fact that the person already overstayed the visa. When somebody finds themselves in removal, they already overstayed their visa, and employment base is pretty much not going to work unless they have some type of exception, 245I. And the fact that the entry with fraud, uh, fraudulent documents, it's like misrepresentation, they have to be able to waive it, right? They have to have a qualifying relative to be able to waive it. But even if they waive that, the green card itself is just pretty much impossible if they don't have 245I. So yeah, I don't think so. In short, basically. So anybody else here has a question so we can wrap up because we don't have a lot of questions. I'm just gonna try to wrap up so we can continue tomorrow. Yeah, if you just got here, please like. If you just got here, please like. Please like. I don't see a lot of like. We got at least 5 people, but I don't see a lot of likes. If you got here, just got here, please like. Please like. So we want to know if you have a question so you can put it in the comment. Yeah, so if there's no other questions, well, I guess I am going to stop for today. Tomorrow we're going to talk about a lot about motion to reopen. So we can try to see if we can reopen some cases and pretty much talk about whether if you have a child, it can help you, a U.S. citizen child, 21 or older. Those are the subject. Sorry, those are the subject we're going to talk about it about those type of subject tomorrow. Okay. But if anybody else has a question, that's the time to actually put it in the comment before we actually wrap up. Hello. It doesn't matter whether the person has TPS or not. The real question is unlawfully present, prior unlawful presence. Can the person waive that with 245I as an exception? If not, employment is not going to work. Those type of TPS works with family base, like immediate family base member. That's when it works, adjusting like that, even though when people overstay. When it comes to employment, you just have to meet the exception of 245I. That's it. There's no way you can waive it unless you have a parent who's a lawful permanent resident. You get a waiver, you get out, but that waiver only waives unlawful presence. What about work without authorization? You see, what about entry without inspection? So yeah, employment base, you really have to have 245I. If you don't have it, it's just not going to work. The moment the person overstay, it just can't work. And the fund and their removal, only 245 can help them. Like the exception, they have to meet the exception. So. Okay, we have a question. What can a U.S. citizen child file? What do you mean by U.S. citizen child filing? The person is a U.S. How come the person is a U.S. citizen and they want to file and they already U.S. citizen? Well, they need N-600. The question, Abdul, it don't even make sense. If the person's already a U.S. citizen, why would they file N-600, all right? So the question itself don't make sense. You have to rephrase your question. Okay? Yeah, Wilbur, you need to watch my previous video, okay? Just Google 245I on my YouTube channel. I've talked about it too many times. I'm not gonna repeat it. Yeah, just watch my previous video on 245I. I have a lot of videos explaining 245I. So Abdul, I guess your question was trying to say who can file for N400, so N600. So basically, if the person is a child of a U.S. citizen, then they can file automatically. Yeah, I guess that's what he wants to say, right? So anyway, if the person is a child of a U.S. citizen parent, the question is, can they file for N600? If they reside here, yes, they can file directly for N600. They don't have to wait for too long because if they reside with the parent and they have at least one parent who's a U.S. citizen, yes, they can file directly if they reside here in America. Okay. So under the age of 18, of course, right? So basically, yeah, under the age of 18. So that's the answer. Anybody else? Any other question? Yeah, so yeah, Abdul, yes, the answer is yes. If the father is a US citizen and the child in question lives in America, yes, and they're under the age of 18, or the father become a US citizen before the child turned 18, yes, the answer is yes, they can file for the form N600. Yeah, if you look at the instructions, very clear, right? So it clearly says that the person is requesting because you were born outside of the United States, but you were born to a U.S. parent. And by the time you're applying, you must be residing in the United States, right? And the condition has to be met before the child turns 18. Parent must be U.S. citizen. You must be the biological child of the U.S. parent. You must be lawfully admitted to the United States, and you must be living in the United States in the legal and physical custody of your U.S. parent. You see how it's going to work? So, yeah, Abdul, did you get it, right? So, can you remove? Do you want to terminate removal proceedings? You have to have a valid reason. Yeah, you gotta have I-130 approved or TPS approved. You can terminate removal with a TPS approved or I-130 approved. Or with prosecutorial discretion if it works, right? So this is it. I guess this is it for today. I'm gonna end here today. If you have additional questions, just put it in the comments. Abdul, if you want to file N600 for your child, just let me know. We can help you with that. Or if you just need a consultation too, um, you can schedule it. All the consultation links are in the description box. And Wilbur, you really need a consultation because you have like all the questions. So you should schedule it too as well. Okay. Until tomorrow, I'll be here with motion to reopen, motion to terminate, prosecutorial discretions, those kind of stuff. Until next time, bye-bye.